the people of the residents of the Northwest Territories. And I would like to thank our committee to observe and share on what we think would be the best interests of setting legislation for this generation and generations to come. And with your input and guidance, we can achieve that. Masi.
Thank you, Mr. Mcmurray. Committee review and adoption of the agenda. There's one item on the agenda today. Does any member have a declaration or any conflict on any matter before us today? Seeing none. Today's committee business is the public hearing on Bill 38, Bill 39, and Bill 44. So without further ado, I want to welcome everyone to our meeting. We are the Standing Committee on Economic Development and Environment. And what I'm going to do to get us started is I'd like to take this opportunity to recognize that we are on the traditional territories of the Catlo-Dichi First Nation, the West Point First Nation, and the NWT Métis Nation. And so it's always important for us to appreciate those lands for which we are working on. I would also like to take some time to introduce our committee members. We have from, of course, your favorite MLA from Hay River North, R.J. Simpson, and from Cam Lake in Yellowknife is Kieran Testart. Myself, Corey Van Thine, I'm the MLA for Yellowknife North and the chair of the committee. We have Kevin O'Reilly from representing Frame Lake in Yellowknife, and of course Danny McNeely representing Saw-2. We also have with us from our Public Relations and Communications, Jean Uris, and we have from the Clerk's Office, Mr. Michael Ball, and from the Research Department, we have Mr. Stephen Dunbar. So it's our pleasure to be here this evening with you, and I would maybe just like to start with some opening comments, so please bear with me. Today, the Standing Committee on Economic Development and Environment is holding a public hearing on Bill 38, which is the Protected Areas Act, Bill 39, Environmental Rights Act, and Bill 44, the Forest Act. The Standing Committee on Economic Development and Environment is a committee of regular members of the Legislative Assembly. The bills we are reviewing today were introduced by the government. They were given first and second reading in the Legislative Assembly and then referred to this Standing Committee for review. The Standing Committee is holding public hearings on these bills in the communities of, last night we were in Fort Smith, tomorrow we'll be in Catlo-Dichi First Nation, today, this evening, we're here with you in Hay River, and we'll also be going to Fort Providence, Betchico, Inuvik, and Norman Wells, and we'll eventually be winding up in Yellowknife. And then we'll be reporting back to the Legislative Assembly on the proposed legislation during the upcoming August sitting of the Legislative Assembly. It is our responsibility as a standing committee to consult with residents of the NWT on what they like or don't like about these bills. We would like to hear your views and comments, which will be used by the committee to identify any changes we would like to see made to the draft legislation, and which we will then report back to our colleagues in the Assembly. I wish to briefly describe the intent of these bills. Bill 38, the Protected Areas Act, proposes to establish new legislation that will allow the GNWT to create permanent protected areas in the NWT where there are important plants, animals, land, cultural, or historical sites. It also allows for co-management of a protected area with an Indigenous government or organization. This bill says what is allowed to happen in protected areas and what is not allowed. Mining exploration, oil and gas development and exploration, and energy developments are prohibited. Small-scale renewable energy projects may be developed within a protected area or by an adjacent community. Roads or power lines may be permitted with consultation of the Protected Areas Management Board. Bill 39, Environmental Rights Act, proposes to change the existing legislation by protecting people's rights to a healthy environment, help ensure the GNWT always considers how the environment could be affected and investigate when a person reports to the minister that someone has harmed or could harm the environment, gives residents of the NWT tools to help the GNWT protect the environment. The GNWT must write a report every 4 years on the state of the NWT's environment, which will be reviewed by the Legislative Assembly and allow time for public comment. Bill 44, the Forests Act, proposes to establish new legislation that will provide tools for managing forests and the use of forests in the NWT to keep them healthy, provide tools to prevent and respond to wildfires, create forest harvesting agreements, permits, and licenses, allows the GNWT to create rules around harvesting timber, and create rules on burning outside communities, allows the GNWT to create rules for harvesting of other forest resources such as berries, mushrooms, and other plants, and respond to insects, invasive plants, and forest diseases. With that, for those who haven't grabbed some of our materials already, there are copies of the bills and plain language materials on the side table near the rear, and so we encourage you to please help yourself with those. If you would like to share your views with us today, please let the clerk know. If you haven't already, most of you who are caring to speak this evening have been in touch with Michael, Mr. Ball, and we'll be sure to get you on a list, but I will be calling out as we move through the process as to who would like to come and speak at the podium in a few moments anyhow. Just so you're aware, if you have additional materials or you care to provide a written submission, we will also accept written submissions up until May 3rd at 5 p.m. One final piece of housekeeping, please remember that all submissions will be part of official committee records and may be reflected in our final report. Any submissions made during this meeting may also be televised or broadcast via social media. So, thank you everyone for your patience in allowing this introduction. With members' agreement, we can now open the floor to comments from the public. Do members agree? All right. Thank you, members. I also want to let folks know that the microphones that we're using this evening obviously are not for amplifying our voices. These microphones are because we are being webcasted or streamed. Yeah. And so these mics are for recording purposes. And so if you are going to be presenting or speaking to us this evening and sharing your comments, then we would ask that you kindly come up to the podium and speak into the microphone, which would be appreciated. So we will start by opening the floor to anyone who wishes to make comments on Bill 38, the Protected Areas Act. And I understand on the Protected Areas Act, Mr. Bailey, representing NWT Métis Nation. If I can have you come to the podium, and we'll turn the microphone over to you.
Thank you. I guess I'll have to talk loud. I've been singing all day, so doing a CD. My vocals aren't very good anymore. Anyways, good evening, committee members and guests. My name is Gary Bailey. I'm the president of Northwest Territory Métis Nation. With me this evening, I have my legal counsel, Mr. Shannon Cumming. He'll be answering all the questions. I'd like to thank the committee for coming to our traditional territory to hear our concerns with the three bills: Protected Areas Act, the Environmental Rights Act, and the Forest Act. I propose to deal with our specific concerns with each bill, starting with the Protected Areas Act, then the Environmental Rights Act, and finally the Forest Act. I'd like to start with a brief overview of the Métis Nation. The Métis Nation is recognized by the GNWT as an Indigenous government. I'm going to say Métis Nation throughout the whole speech, and I mean the Northwest Territory Métis Nation, and I'll probably use the abbreviations like PAA and stuff like that rather than going through the whole thing. So the Métis Nation is comprised of Indigenous Métis from the indigenous communities of Fort Resolution, Fort Smith, and Hay River. We have a long history in the NWT based upon our way of life, traditional harvesting practices, and use and occupation of the land, the assertion of the sovereignty by Canada. And before the signing of Treaty 8 and 11, the Métis Nation was the backbone of the Hudson Bay Company trading network throughout the NWT, and beyond. The Métis Nation signed a framework agreement with Canada and the GNWT in 1996. The Métis Nation signed a land and resource agreement in principle with Canada and the GNWT in July of 2015. We are currently finalizing land and resource and governance negotiations with the Government of Canada and the GNWT under the NWT Métis Nation Framework Agreement. The matters under active negotiations include the same matters as those described in the Protected Areas Act, the Environmental Rights Act, and the Forest Act. One of the fundamental outstanding issues remains how the Métis Nation will be meaningfully involved in the co-management of land, resources, and water. The Métis Nation Land Claim Agreement under negotiation will be a constitutional protected document as a treaty under Section 35 of the Constitution Act. The Métis Nation is a party of the devolution final agreement. We consented to devolution in good faith, with the expectations that the government of the Northwest Territories would change the way it does business with Indigenous governments when developing policy and legislation that may impact our Aboriginal rights. As a condition of devolution, the Northwest Territory Métis Nation entered into the Northwest Territories Intergovernmental Agreement on Lands Resources Management 2013 that included a process for the Northwest Territory Métis Nation to participate in the Intergovernmental Council. The duties of the Intergovernmental Council include reviewing and developing changes to the GNWT laws respecting lands and resources. 5.1. The duties of the Council are to A. Review the land and resource management system of each party. B. Review and develop any proposed changes to the systems described in subsection, including any associated legislative, policy, or organizational changes that are necessary to further the purpose and objectives listed in Section 2.1. The purpose of the IGC is to formalize government-to-government relationships and to provide meaningful role for Indigenous governments in a cooperative and coordinated management systems for land, resources, and rights in respect of the waters in the Northwest Territories. The IGC reflects the promise that devolution would foster government-to-government relations and co-management of legislation on land management. The Métis Nation technical representatives Jake Heron, our chief negotiator, and Shannon Cummins, legal counsel, participated in the GNWT Technical Working Group to develop the Protected Areas Act, the Environmental Act, and the Forest Act. While we appreciate the opportunity for our officials to participate in the technical working process, the draft act remains subject to our review with the political leadership of the Northwest Territory Métis Nation to ensure the acts do not adversely affect or infringe upon our Aboriginal rights. On October 11, 2018, the Supreme Court of Canada released reasons for judgment in Mikisew Cree First Nation versus Canada, Governor General and Council, 2018 SCC 40, in respect to the Crown duty of consultation related to the development of environmental legislation. Importantly, the court went to great lengths to confirm the Crown owes a duty of consultation when Crown action may adversely affect Aboriginal rights. 25. In instances where the Crown contemplates executive action that may adversely affect a Section 35, the Honour of the Crown has been found to give a justiciable duty to consult. The duty to consult ensures that the Crown acts honourably by preventing it from acting unilaterally in ways that undermine Section 35 rights. The court held there is a strong incentive to consult before passing legislation, paragraph 167. The duty to consult is an obligation imposed by the Honour of the Crown in instances where the Crown contemplates executive action that may adversely affect Section 35 rights. The Honour of the Crown has been found to give rise to a justiciable duty to consult, paragraph 25. The duty to consult ensures the Crown act honourably, paragraph 26. The Métis Nation expects the GNWT to maintain the honor of the Crown in all its dealings with us, particularly in respect to the consideration of the concerns as the acts may adversely affect the exercise of our Aboriginal rights. We look to the GNWT to maintain the honor of the Crown while our land negotiations are underway. The Métis Nation has requested a meeting with ENR Minister Robert C. McLeod to address our concerns with respect to the PAA. To a government-to-government meeting is required to address our concerns before any final approval of the PAA. The Métis Nation is concerned that the schedule and time restrictions rules of the Standing Committee does not respect our government-to-government relationship. While the NWT Métis Nation does not oppose the introduction of the PAA in the Legislative Assembly, I want to be clear that the Métis Nation has the following concerns of the PAA. Section 15, 1B enables the GNWT to establish a protected area with just one Indigenous government, irrespective of whether other Indigenous groups are in support. 2, the PAA must expressly subject to carrying on of traditional renewable resources harvesting activities by Indigenous persons. And 3, the PAA must include an express provision to enable future corridors for transmission lines and roads for future development. Section 15, 1B of the PAA has been structured to enable GNWT to proceed with the establishment of a protected area with the support of only one Indigenous group under Section 14 through the Establishment Agreement. The Métis Nation is very concerned that the GNWT will use the PAA to prevent any efforts by the Métis Nation to question the proposed East Arm protected area, even if there are no benefits to the Métis Nation arising from the proposed established agreement. Under Section 15, 1B, if the GNWT determines there are irreconcilable differences during negotiations with an Indigenous group in respect to the proposed protected area, GNWT can simply dispense with their free, prior and informed consent mandated by the United Declarations on Rights of Indigenous Peoples and merely engage in a consultation process under Section 15.3 with the Indigenous group. This unilateral action by the GNWT creates conditions where the interest of one Indigenous government would be preferred over the interest of another, which is inconsistent with the honor of the Crown and the GNWT's commitment to a government-to-government relationship with Indigenous governments. The PAA cannot be used to wedge a drive regional and community Indigenous governments apart. The GNWT must give serious consideration to the potential effect of such a clause on the relationships amongst and between public and Indigenous governments. Further, we note that the term irreconcilable differences is utilized in divorce proceedings for no-fault divorce. We question the appropriateness and such drafting language in the proposed act. These provisions are not reflective of the government-to-government relationship we have. It has the potential to set up a situation where the GNWT can take unilateral action and play one Indigenous government against the other. In order to fast-track a protected area, the GNWT is duty-bound to exhaust every effort to resolve the differences. We suggest that the sections on establishment agreements be amended to remove the reference to the minister taking unilateral action by proceeding with an establishment agreement where only one Indigenous government has signed on through an establishment agreement. Subsection 14.4 could read as follows. The minister shall make best efforts to enter into an establishment agreement on the recommendation of the Executive Council with one or more Indigenous governments and organizations. We further recommend that the subsection 15.1b, the provision on reconcilable differences, be removed in its entirety, and this subsection does not uphold the honor of the Crown of the GNWT to meaningfully address the differences. Our next concern with the draft PAA is the provisions in respect of Aboriginal rights. we are concerned that the PAA does not sufficiently protect harvesting activities in a protected area. Section 3 of the PAA contains a general statement about the Act being interpreted in a manner consistent with Section 35 of the Constitution Act 1982. This Act is to be interpreted in a manner consistent with the recognition and affirmation of existing Aboriginal and treaty rights, Section 35 of the Constitution Act 1982, including the duty to consult. Despite this interpretation clause, it has been the experience of the Northwest Territory Métis Nation that the GNWT exercise a lot of discretion regarding GNWT's interpretation of its own obligations. GNWT's property tax assessment of traditional use cabins under the Territorial Property Assessment Act has created a situation of GNWT infringing the ancillary rights of our members to build and use cabins. Section 3 of the Property Assessment Act provides a similar clause as Section 3 of the PAA. Nothing in this Act shall be interpreted so as to affect Aboriginal rights. Despite this clause, GNWT has been assessing some of our cabins for taxation and has increased lease fees. Property taxation on cabins and lease fees constitute an infringement of our Aboriginal rights due to the effect it has on the terms conflicting with our recognized Aboriginal rights. Indigenous Métis members have the right to build, use, and occupy cabins incidental to their traditional harvesting purposes throughout the Northwest Territories and the Métis Traditional Territory without paying an $840 lease fee and without being subject to property taxation. This issue has been raised during their land claim negotiations, during meetings with cabinet ministers and senior GNWT officials. Despite these efforts of the Northwest Territory Métis Nation, the Property Assessment and the Taxation Act has not been amended to exempt taxation on traditional cabins. The Métis will continue to advocate for the recognition of traditional use cabins free from taxation and lease fees. Accordingly, the PAA must provide an express provision about the exercise of traditional harvesting activities. The PAA must contain a companion clause to that found in the Canada National Parks Act, which provides, number 40, the application of this act to a park reserve is subject to the carrying on of traditional renewable resource harvesting activities by Aboriginal persons. Everything being equal, the PAA must meet the minimum thresholds of Canada's National Parks Act. If, as we fear, the PAA passes without the change to the section dealing with establishment agreements, the Métis Nation will be left in a situation where co-management bodies of the ENR officers may make their own determination on whether Métis, Aboriginal, or treaty rights to harvest in a protected area. This is fundamentally unfair to the Métis Nation. We work tirelessly to have the Métis rights reinstated in Wood Buffalo National Park, and we will not stand by while the GNWT or its co-management partners take steps to shut out the Métis from carrying on activities in areas to be taken up for a territorial park. Métis harvesters have a long and painful experience with being excluded from areas such as Wood Buffalo National Park. We look to the GNWT to ensure Métis rights to harvest are not infringed by the territorial legislation. Section 27(3)(a) of the PAA provides wording that requires evidence of Aboriginal rights with an identification card that exceeds wording incomparable to the Wildlife Act section. 3A, a person claiming to exercise an Aboriginal or treaty right in a protected area shall A, carry proper identification that provides evidence that the person has an Aboriginal or treaty right. For your reference, Section 18 of the Wildlife Act provides a person claiming to exercise an Aboriginal or treaty right to harvest wildlife in an area of the Northwest Territories shall A, while harvesting game or other prescribed wildlife, carry proper identification to harvest in the area. Clause 27(7) must be deleted, as the Wildlife Act deals with identification requirements when harvesting. This provision is not consistent with Section 18 of the Wildlife Act. We believe language found in the Canada National Parks Act is more prescriptive in upholding the rights of the Métis harvesters in the park. We suggest that the language be incorporated into the PEA along the lines of a protected area is subject to the carrying on of traditional renewable resources harvesting activities by Aboriginal persons. Our next concern deals with the transportation or transmission corridors. The Métis Nation is of the view that the legislation should make provisions for corridors for transportation and power transmission to allow for strategic economic development initiatives such as the Tolson Hydroelectric Expansion Project. The Métis Nation views the Tolson Hydro Expansion Project as an opportunity to decrease significantly the NWT's dependence on greenhouse gas producing diesel power and to spur environmentally responsible economic development in the areas to the east and to the north of the Great Slave Lake. We note that subsection 14.3 Z2 deals with the requirements and proposed processes for approving transportation and transmission corridors in context of establishment agreements. However, we have previously stated our concern with being excluded from the establishment agreements, so we take whole comfort from this provision. We also note that subsection 36.1 allows the minister in the public interest to identify land within a protected area for transportation or transmission corridors. However, these actions are subject to the subsection 36.2, which requires consultation with any management boards established for the protected area. We have serious doubts that a management board would agree to such a proposal. We also know from our own experience with the Dese Energy Corporation that any proposed corridors would likely have strong resistance from the community of Lutzique. For the GNWT to depend on Section 36 for establishing corridors is like trying to put toothpaste back in the tube. You're essentially asking to create a huge protected area. Then you're asking the Park Management Authority to carve out an area for a corridor. I think I know what the answer will be. The Métis Nation supports the introduction of the ERA to the Legislative Assembly. The bill expands the scope of the existing ERA for investigations, prosecutions of offenses, and bringing actions to protect the environment. However, the ERA needs to provide a mechanism for an Indigenous government to make an application to the GNWT if the Indigenous government has grounds that an act or omission has caused or is likely to cause significant harm to the environment. We are aware that the former ERA was employed very infrequently. It is our hope that the modernized ERA will ensure that the legislation is utilized as needed and that the right to a healthy environment is realized. The Métis Nation would like to be involved in the development of the regulations for the ERA. The Métis Nation proposed the following amendments. Any adult resident or Indigenous government in the Northwest Territories who believe on reasonable grounds that the act or omission has occurred that has caused or is likely to cause significantly harm to the environment may apply to the Minister for an investigation. The Métis Nation, this is the Forest Act, I guess. The Métis Nation does not oppose the current bill of the FA. We do, however, have significant concerns with the process and a timeline with the bill. The Métis Nation only saw the draft FA in December of 2018, which did not allow for sufficient time to engage with ENR officials on the policy and the legislative aspects of the FA bill. Without these government-to-government discussions, the FA would have better reflected the principles that underpin other legislative initiatives. It appears that much of the substance of the bill will need to be taken up in the regulation-making phases. This is not ideal for a number of reasons. As well, it will require significant work at the Standing Committee stage to make the required changes to the bill, and we are concerned that the Standing Committee process is ill-equipped to undertake such substantive work. The FA needs to provide express provision about the economic accommodation of the Indigenous rights. For example, the British Columbia Forest Act provides for various accommodation measures with Indigenous groups, including interim measures, revenue sharing of crown stumpage, royalties, establishment of First Nation woodland areas for management areas, First Nations tenure, opportunity agreements. However, we take the GNWT at its word that they propose to work with Indigenous governments to further refine the FA through regulation-making processes. We appreciate that ENR took steps in March to make additional provisions in the FA to meet the concerns expressed by several Indigenous governments. For example, the new language referencing renewable resource boards provide comfort to Indigenous governments currently in negotiations that the FA will respect the structured setup of the final agreements, both those which are concluded and those yet to be concluded. In addition, we are pleased to see subsection 7.7, which provides that the minister may enter into agreements with governments, persons, bodies, or organizations with respect to the minister's responsibility under subsection 1 and powers under subsection 5. We look forward to continuing to work with ENR in developing the draft FA and regulations that can be supported by participating Indigenous governments. While the timeline proved challenging, given the legislative windows, your officials worked diligently with Indigenous governments to develop the policy and legislative aspects of the legislation. There were many times when our officials worked with the Indigenous government counterparts to seek creative solutions to develop approaches that achieve mutually successful outcomes. I want to commend them for their hard work. I believe this speaks to the success of the technical working group in developing the legislative initiatives, and I encourage you to continue to provide ministerial support and funding for the ongoing collaborative work to develop the legislation and regulations. We are disappointed that two major pieces of legislation, the Waters Act and the Environmental Protections Act, are not ready for prime time. These are critical to the overall management regime, and we will continue to work with you on the legislation when it comes forward. Finally, I want to underscore the remarkable efforts that the Indigenous governments have made to work together and to work with you on these critical legislative initiatives. It is important that we take the time to reflect on what we have achieved in this process. Some of the participating Indigenous governments have faced each other in court and in the political arena and have taken the hard positions on critical issues. We have agreed to drop our shields and to work together for a common outcome. In doing so, we have taken steps to develop a suite of legislation that could make us all proud of our collaborative efforts, to work together to seek common ground and to manage our land and resources as true partners with shared powers and shared responsibilities. If we maintain our approach through the regulation-making process, we could achieve the vision that the Devolution Agreement and the Northwest Territories Intergovernmental Agreement on Lands and Resources Management Act has promised. We see this work as a key aspect of the GNWT's interest in achieving reconciliation. In summary, we look forward to the committee in giving due consideration to the concerns of the Northwest Territory Métis Nation. We also intend to file written submissions to the committee that will give you our concerns and our suggestions. Thank you again for coming to our communities, and I guess we can answer some questions if you have some questions. I hope I didn't take up too much time.
No, well, Mr. Bailey, thank you very much. I think I can speak for committee in saying that we're very appreciative of your substantive and extensive, very detailed submission, your background to us with regard to Métis Nation, and of course the detailed kind of background information you gave with regard to government relations and the Constitution in particular. Section 35 is much appreciated as a kind of a preamble to your submission, and appreciate that you commented on all 3 bills that we have before us that we're reviewing. So
I will give you guys a copy of it. I just have it in my binder here.
thank you, and that's what I was going to ask, and whether you can give us a hard copy or a digital copy would be very well appreciated. And we'll turn that over to Michael Ball. And if committee has any questions that they would like to ask, I'll start with Mr. Simpson.
Thank you, and thank you for the very thorough presentation. I appreciated it, and I look forward to digging into the written submission so we can, I can really look at some of those clauses that I missed during your presentation. You talked a lot about the role of the IGC and the technical working group and co-drafting with Indigenous governments. And when I look at the devolution agreement, it seems like the role of the standing committee wasn't really considered when that was being developed. And so it's unclear to me what the role of the standing committee would be ideally to Indigenous governments. Because ultimately what happens with legislation is the government creates legislation, it goes to the standing committees and then to the legislature. But with devolution legislation, there is a substantial input and collaboration with Indigenous governments. And that all happens before it gets to standing committee. And I was wondering, does the Métis Nation have a position on how it would like to see legislation drafted in the future with respect to the role of Indigenous governments, the GNWT, and the standing committees? Is there a different a flow that the Métis Nation would like to see, or different timelines, or things happening at different times? Thank you.
Well, as you know, we were part of those technical groups. I think those were a very good start. You know, that's, you know, the Mikisew Cree went to court as well, and they did lose in court. However, we have a different relationship with the GNWT. We have agreements to work together on government to government relationship. So I think that's the first step, is having that technical group. Of obviously not everybody agrees with what happens at that technical group. That's why we're here, you know, because the standing committee is going to make recommendations to the cabinet as well. You know, I really strongly believe that based out of the presentation, you'll see what our concerns are. You know, I think it's very important that no one group has the say to create a park. You know, you look at my community that I'm from, Fort Resolution. Well, that's the oldest community in the Northwest Territories. Now, we talk about Lutsuke. They were created in the 50s. They want to create a East Arm Park. Bulldoze whatever rights we have, you know. We want to make sure that if there's going to be a park there, we're involved in it. We benefit from the park for giving up those lands. I believe you guys can help us with that decision to make sure that there's a proper process where all the Aboriginal groups work together, regardless on how old my community is or whatever. I'm willing to work with the other Aboriginal groups, but we got to be able to have those talks, and one community can have say over what happens in the north. So I believe the standing committee can make that change for us. This is the only time we can to do this. Otherwise, you know, we're going to be just like it was back in all the other days. You know, we got to fight you guys in court, and you know that's not why we signed into devolution. So I don't know who you are then right now. No, but yeah, that's what I think. I think it's got a good start. I think the technical committee's there, and then you got your standing committee. So I think it'll work.
All right.
I have faith in you guys.
Yeah, well, I was just going to say that. Thank you for your faith in us. So next I have Mr. Testart.
Thank you, Mr. Chair, and thank you, Mr. Bailey. So I was going to say that as well. We are not representatives of the Crown. We're representatives of the people duly elected to serve in the Legislative Assembly, and that's where we come in at this point, is to be the eyes of the people on the government's legislation, on the legislation of the Crown. I don't think we're mutually incompatible with the IGC process or Chapter 6 of the devolution. It's just something we're coming to terms with because we haven't dealt with legislation like this until this point. My question for you is around your concerns that one group could put their preferred interests, and you could have a government, making a deal with picking and choosing essentially who gets protected areas and how that affects other things. Federal legislation, which you referenced in your submission as well, has a different process where a protected area, like a national park, will come forward as a separate piece of legislation that's then added to a framework regime as a separate schedule in the Act. So essentially, any park that was created or any protected area that was created would require a bill to be brought forward in our legislature and for all MLAs to vote on it, not just an agreement in regulation. If an amendment was sought that did that to this bill, where any any other protected area that came forward would have to go to the House for approval by all MLAs, would that address some of your concerns?
It's tough to say because right now I don't have an MLA. I have one MLA who's working for 3 other communities, so no, I don't think so. No offense, but I mean, we're like, you look at Fort Resolution, we're sharing one MLA. And Yellowknife, how many MLAs do you guys got? 7? I think it needs to rely on the indigenous members of the Northwest Territories to help draft that. That's no offense. I mean, the bottom line is we have to protect our own interests.
Okay. Thank you for the feedback. Next I have Mr. O'Reilly.
Thanks, Mr. Chair. So I guess I'd like to start by thanking you for your submission. Lots of detailed comments. I took about 3.5 pages of notes, and I look forward to the written submission. And I think I heard you say that there might be further submissions on each of the bills, and I would encourage you to do that. And there's been some very practical suggestions on wording and changes, and I really appreciate that. I think that'll be very helpful when we come to deliberate what kind of changes the committee wants to bring forward and respond to everybody's concerns. So I guess one thing I do want to say is that although I'm from Yellowknife, I did actually work at the Dene Nation for a number of years, and so I think some of us have some appreciation for Indigenous rights, and just that's a fact of living in the Northwest Territories these days. So, but I do have a couple of specific questions for you if I can, and you said that you weren't very happy with, I think it's Section 15 in the Protected Areas Act, 15.1, where the minister can basically force the establishment of an area even if only one Indigenous government agrees, and there's others that might be interested or have rights involved. What sort of process, you mentioned that you're okay if there's some best efforts to try to reach an establishment agreement if there's a bunch of different communities or governments that are interested. Is there any kind of mediation arbitration process that you might suggest or look at? Or do you just want to sort of leave it to I understand you don't want to leave it to the discretion of the minister, but how is there a mediation arbitration process that you might think about? Thanks.
Well, if there's going to be a protected area established, you're obviously going to be taking away lands from, I'm going to speak just to the Métis Nation, okay, from the Métis Nation. The Métis Nation is on the south of the lake, and as you know, the economy in the south of the lake is not good. So by creating a park there, we're losing out on opportunities. You have the Mira out there. I don't know, there's been a lot of doubt about the Mira, about how well of a job it's done in the East Arm area. So we feel that there's opportunities that we could be losing. I also mentioned in my notes that I said we have to benefit from any park. So in order to do that, you have to get together with us, and there has to be some kind of a negotiations, an agreement. If you're not affecting my way of life, my hunting, my harvesting, my traditional way of life, but you're going to be taking away the economic opportunity from all those lands, there's got to be a way that we can talk and negotiate on some sort of a benefit for the Métis. Not just to sit on a board, You know, politics is not what we like to do. You know, we like to live out on the land. We like to be out there. We like to benefit in those ways, for sure. But I tell you, you know, I like the idea of a protected area, but we have to benefit from it, and we have to be part of it. So, that's it, yeah.
Okay, thanks. I appreciate that. My last question for you is, I know tonight you've talked about your experience working with E&R, and I know that you had to work with other departments on other bills that we're going to probably come back and get your views on as well.
Mm-hmm.
The ones that Industry, Tourism and Investment developed, and then we're going to have to come back maybe even one more time for a Public Land Act that Department of Lands developed. So I'm wondering if you can think about what was learned from each of the approaches that those different departments took, and what kind of recommendations you might give us and back to Cabinet about how to improve that co-drafting process and consistency across all those different departments that you guys worked with. Because we've seen some differences ourselves in trying to work with each of those three departments. And I just want you to think about that. You don't have to respond now if you don't want to, but it'd be great to hear your views about how those three different departments approached you guys, and what kind of lessons you want to get from that and pass on, and how we can improve that process in the future. Thanks.
Okay, I'll take a short crack at it. You know, reconciliation is the biggest thing going right now for all governments. You know, we've got a chance here to honor the Crown. In all our negotiations, all of our issues we've had, like Section 3 of the Property Assessment Act, speaks, there's a clause in there says government has the right to tax all lands in the Northwest Territories. Then in small print it says, however, it cannot affect the Aboriginal way of life. So to us, that means you don't put a cost to us having to go out on the land. If we want to put a cabin there so we can go out, and even our grandmothers, if they want to pick berries, whatever it may be, teach our youth, you know. We need a fair-sized cabin. Some families have seven people. You know, my grandmother had 18 children. 21 she had. 18 of them survived. You know, they had a small little 16 by 16 cabin. You know, it wasn't big enough for the families. They need to recognize our inherent right. They have to look at us as if this was our land, and you guys are here on our territory, and we're going to coexist together and have a mutual agreement. They have to honor that when we talk about reconciliation. You know, I spent 4 years, maybe longer, fighting the Taxation Act. I've had meetings with the ministers, I've had meetings with their lawyers, I've had meetings with their technicians, and not 1 inch have they moved. They still say, I have our opinion. Our legal counsel said it does not affect your way of life. Even though I've given them so many examples of how it affects our way of life. You know, I think the people are there to make decisions and not hide behind policies. Yeah, that policy says that. And if it's unclear, we have a government-to-government relationship here. We signed on to devolution to work together, to recognize each other's coexistence. You know, they have to honor that. And if they think that way, we're pretty friendly people. I have nothing against any people coming to our country. I mean, the more the merrier, as long as we can respect our Aboriginal rights, you know, from our ancestors who've been here since the 1400s. We've been here since time immemorial. We've been here. So if they respect that, we'll get somewhere. That's the best advice I could give you, and I appreciate the fact that you said you were part of the Dene Métis. I'm not judging any of you guys at that level. I just know that we fought long and hard for self-government, and we're there now. We're there right now. So if we want to do it together, we're willing to do that, but we have to do it on a government-to-government basis. Yeah.
Thank you for your response. Next I have Mr. McNeely.
Thank you, Mr. Chair, and thank you for your condensed presentation reflecting all three bills into one. And I look forward to the material that you're going to give to the committee. I wasn't part of the discussions in my area in the SA2 when the SA2 Secretariat was invited as part of the preliminary discussions of the technical working group. But your experience in that, you can call it kind of a co-drafting process. And Mr. O'Reilly highlighted that process could be reviewed and see how it could be improved for further legislation.
Mm-hmm.
But I just want to ask you a question on that technical working group. I see a list of organizations that were invited, including yours. How was that process? Did it address most of the concerns that you brought forward today? Did you find it productive, I would say? Thank you.
Well, I can only tell you what I've heard. So what I'm going to do is I'm going to look to Mr. Cummins over there, who actually sat on that committee for me, because I wasn't on the committee myself. So Shannon, if you could come up.
Please just state your name into the microphone.
Thank you. Good evening, committee members. My name is Shannon Cumming, legal counsel for the Métis Nation on the legislative initiatives. In response to Member McNeely's question, the technical working group has been really successful in helping to collaboratively develop legislative provisions for much of the legislative pieces that are before the committee. I think when we reflect on how things went, you may get slightly different views from each of the Indigenous government partners, but I think you'll find there's a fairly common view that we went a long ways down the road to achieving the vision of the devolution agreement and that notion of actually co-developing, co-drafting legislation. Not a situation like in the past where the government would write the legislation and then bring it out for consultation. What we strove to do, I suppose, was to create a situation where each of the parties would feel comfortable with recommending this legislation to their respective constituencies. I think the things that worked well was having the opportunity to share our views on not just the legislative pieces, but the policy reasons behind it. So we were able to talk about what our interests were as Indigenous governments in developing this legislation. I think where we may have fallen short, and it's not to lay blame anywhere, but I think where we may have fallen short is that we just did not have the time. The windows were too tight. As you well know, the windows for introducing legislation to the House have really been cranked almost shut over the last few months, and it was nearly impossible to conclude the important work that we had before the legislation just had to be put into the House. Now, looking back to when devolution was agreed upon, I wanted to highlight what President Bailey said earlier, which is that the Indigenous governments signed on to devolution in good faith because they were promised, there was a political commitment made that there would be developing legislation together. Now, it raises an interesting issue for the committee, because I think Mr. Simpson pointed out earlier that question, what's the role of a committee like SCEDI if there's this process going on and then the committee gets the legislation? How is that to be treated? I would suggest, I guess in the experience that we had, that it may not be the worst outcome. In one sense, perhaps SCEDI feels it's been sidelined as this legislation is rolled out. On the other hand, the process with the technical working group and the co-drafting that we worked on helped to clear a lot of the brush, if you will, in bringing that legislation forward. So we had some very good and intensive policy discussions and then we would see a draft of the legislation. In terms of the actual co-drafting, I don't think we ever actually got there. During the Wildlife Act and Species at Risk Act, we actually had legislative drafters sitting with the Indigenous governments. That didn't happen this time. They were participating, but kind of at a distance. And so it was work being done at the officials level. In our view, I think there's still an important role for a standing committee. Even if the process is different as it was previously, I think standing committee has a very vital role to play in reviewing the work that's going forward. And I think what you've heard from many of the Indigenous governments is that we've done a pretty good job working together to bring the legislation this far down the road, but we could do it better. And I would invite the members of SCEDI to think about how they could use the important role they have to review legislation and make recommendations on it. I still think there's a very vital role that SCEDI can play in reviewing the work that's going forward in the House. In fact, it might be, I won't say easier, but I think a lot of the big outstanding issues will be very evident for committee instead of having to deal with a laundry list of a lot of other technical issues. So you may find going forward, for those of you that'll be in the next legislative assembly, you may find going forward that this process might be attractive to the committee because you'll be able to focus on some of those key outstanding issues. I hope that sheds some light on the process today, and thank you.
Thank you. Thank you, Mr. Cumming, for your very detailed response. Much appreciated. And I believe we might have one more question left. Mr. Testart.
If I could ask Mr. Bailey a question. Mr. Bailey, you mentioned, sorry to get you back up to the microphone, but you had mentioned when you were speaking about Bill 44, the Forest Act, that you felt that the standing committee process was ill-equipped. I believe that's the words you chose to use in your presentation, to address the concerns the Métis Nation has with the bill. And you spoke, but you did speak to the success of the working group, and did raise those concerns. So I know many members received a lot of correspondence from various Indigenous nations on the very serious concerns they had with the co-drafting process around the Forestry Act, the rushed process, the sense that there were some significant issues, and even a recommendation quite publicly from the Dene Nation not to proceed with the bill. And many members did in fact vote against it at second reading. So I'm wondering if you can share your perspective, if you feel that in fact what work we do at this stage is actually going to improve the bill, or whether or not the bill needs to go back to the drawing board, back to the technical working group for more work. Is it crucial that this bill continue to move forward at this stage, or should it go back? Is there a formal position or an informal position you can share with us? Thank you.
Well, I still think it needs to go back. Like I said, it's been fast-tracked. There hasn't been involvement. So it's hard to nitpick the whole thing right now. I would probably get my legal counsel to come up and nitpick it, but at this stage, we feel that it shouldn't go any further. It needs to go back to the drawing board. And as even the Dene Nation is not in support of this, and we weren't in support of it either at the time. But I mean, it was too late. So our last hope is right here. So like I said, it was pretty fast-tracked. We didn't have any input.
Thank you.
Thank you very much. Thank you for your submission tonight. Very much appreciated. So without further ado, I would like to see if there is anyone else who wishes to speak to, we'll go back to Bill 38, the Protected Areas Act. If there's anyone in the audience this evening that would like to speak to Bill 38, the Protected Areas Act. Bill 38, the Protected Areas Act, is more to do with the parks preservation. We do have the Environmental Rights Act as well.
I just got a few questions. I'm going to keep it straightforward and simple. My name is Ken Como. I've been in the territories for 38 years, raised a family here, got grandchildren, they're Aboriginal. And the concern is great for the environment, you know, the fishing, the hunting, the ecology, all of animals and the birds and what's happening. And my concern right now, and it always has been my concern, is regarding what's happening down south. And I'm sure you can realize what I'm talking about, which is the Fort McMurray oil sands. Right now, the federal government and the provincial government are pushing to put that Trans Mountain pipeline through. When that goes through, Fort McMurray production is going to triple, double, whatever. It's going to extend extensively. And I'm wondering what's going to happen when they do that, all that production. Right now, they're using tons of water. They're putting affluent, as far as I'm concerned. They got these tailings ponds that are building that, as far as I can understand, their life is for what, 12 years, those tailing ponds? Are they getting bigger? Are they getting weaker? What's happening to them? How many ducks to date have been killed? Is there any record kept of that? They're using massive uses of water for the production, and I'm concerned about what happens with the NWT. We're dealing right now, I understand, with what happens in the NWT with these regulations. What about cross-border regulations? Is there cross-border regulations in regards to the NWT and oil sands? That referring to status cross-border regulations, Alberta and BC. As we know, in BC, they're building that sea dam along the Peace River. That's in conjunction with 2 dams that are already there. Now, that's going to affect the watershed in the Athabasca, as well as the Mackenzie River Basin. And that's going to have long-term effects on the fish and the water supply coming up north. What kind of agreements do we have with the trans-border? Are the regulations in place? Are they enforceable? Are they being discussed? I don't know. Does the NWT government have jurisdiction to enforce regulations or impose cross-border regulations to hold Alberta oil sands financially responsible for toxic environmental damage from polluted waters? That's a legal question. I don't know. Is that a consideration for what's happening with, the regulations? Are we going down that road? Are we just going to let something happen and then close the barn door after something happens? I'm referring to what happened in Yellowknife with your gold mines. Regulations didn't do anything till after. Now, who's responsible? The taxpayers. The regulations are good, but there's got to be oversight and there's got to be enforcement. And right now, is there enforcement? What's the cumulative effects right now? They've been doing environmental audits, every 5 years. I want to know what's happening. I want to know what the cumulative effects are, what's happening to the fish, what's happening to the cancer clusters in Fort Chipewyan, about the legions on the fish, about the people scared to eat the fish, drink the water, use the water. What's the status of that? And that's going to have effect on the people up north, not these local regulations and that sort of thing. You've got to go cross-border and enforce. And it's got to be kept on top of, or else our generations, I'm concerned. I'm not concerned about myself. I'm aging into my 70s. It's my children and my grandchildren and the people that follow after that. Sure, you get short-term benefits from oil production and everything else. Everybody makes big money. But then down the road, your kids suffer because the pollution, the environment, the toxicity of the waters, the fish, the air. It's okay to talk about it and make plans and we're going to do this, we're going to do that. These things right here, when are they going to be enforced? You got to discuss them in government this August. Are they going to be enforced right away? I don't know. Who knows? And your 4-year report, is that in conjunction with the audit that's coming in, the environmental audit? Do we get up information? Is this information going to be passed effectively to the people? Maybe you should go into the schools and talk to the kids. The kids can talk to their parents. You're not getting much of a crowd here. Go into the senior schools and talk to the kids. Kids talk. They got their little phones. basically, that's my concern. I'm just going to keep it short, just to cover those aspects.
Okay.
There's other things to deal with because of the fact that Fort McMurray, when they go into big production, there's going to be all kinds of things coming down. Not only the water and the land, the natives have a saying, the water is the blood, the land is the body. Keep the toxins out of it.
All right. Thank you, Mr. Como. And I think you have a lot of questions in there, and there's maybe a couple of members here that can provide a little bit of clarification to you on that. I can let you know that, unfortunately, and as Mr. Bailey had alluded to earlier, the Waters Act has not come forward in this assembly. That'll come forward in the 19th. I believe, we're hoping. I mean, that'll be the government of the day's decision, but recognizing that matters similar to what you have raised are very concerning, and that, of course, amendments to that act are required on an ongoing basis. We do have transboundary water agreements with a number of the provinces, and including, I believe, the Yukon Territory. I think we're working on our Nunavut agreement. But that will be something that the government, as well as the standing committee, will have to do something similar to what we're doing now in terms of amending it and or revising it in the future. But it's not to make light of the situation. Water clearly and its care and maintenance has been an ongoing issue, especially as it relates to a number of the Indigenous governments. They fundamentally have been the keepers of water and land, and so the governments of the day have to respect that, and most certainly will be paying attention to that to the greatest extent possible, at least from our end. Can we and shall we and will we continue to work with other governments, such as the province of Alberta, to the best we can? I'm absolutely sure that we can and we will. But if there's others at the moment that would like to, maybe Kevin, you could elaborate a little bit more on just a couple of the concerns that you raised, especially around the waters. Kevin is, I look to Kevin because Kevin is kind of our resident environmentalist on our committee, and so we have a lot of regard for what his knowledge brings to our committee. So maybe I'll turn the mic over to him quickly.
Thanks, Mr. Chair, and thanks, Mr. Como, for coming here this evening. You've raised a lot of concerns and issues around water, and but you've made some specific comments that I think do relate to at least one of the bills that we're looking at tonight. That's the Environmental Rights Act. You know, you've talked about there is to be a 4-year State of the Environment reporting done under that bill, and how does that relate to the environmental audit that's being done under federal legislation, the Mackenzie Valley Resource Management Act? I've raised that concern myself, and it's good to hear from a member of the public as well. I think those two seem to be some overlap, and we want to make sure that those two things are coordinated properly. So I think that's a very good concern to raise here this evening. And my colleague talked about how there is transboundary water agreements. Those are, you can see them on the ENR website, and there is supposed to be annual reports done about how those are implemented and so on. They largely revolve around testing of water and fish to try to make sure that the water that comes across the border is safe for our people here and is safe for fish. I think more work can and should be done on those, and that should probably be captured in the State of the Environment reporting that's done under the Environmental Rights Act. So I think that's a good concern to raise here again this evening. Yeah, a lot of some of the other issues you've raised are issues of government, and the role of us tonight as a committee is to review these bills. But that's not to say we're not hearing and listening to what you're saying, and we can bring those concerns forward to our cabinet colleagues as well. So I just want to thank you again for coming here this evening, and I think you have raised some concerns and issues. You also talked, about financial responsibility, financial security. That's going to be dealt with in another bill that we're going to probably, I think, come back to Hay River on the Public Land Act. And so I would encourage you to, I've noted it in my notes here, and I'll make sure that it gets reflected in what we bring forward on the Public Land Act as well. But thanks again for coming.
Okay, the past audits, do you guys review those, and as far as what the the cumulative effects have happened? Do you review those, and do you review what action was taken, if any action was taken, to remediate any problems? The oversight, is there oversight? I know you, federal government environmental minister there, said there's oversight of only, what, every 18 months or so?
Yeah, on the environmental audits in particular, those are done, there's a group, a steering committee of the Indigenous governments, GNWT, the federal government. They all work together to hire an independent auditor. And that auditor will, the first thing that they do is pick up the last audit that was done and look to see whether the recommendations from that one were actually implemented or not. And so then they report on that. They also report on other observations from interviews and looking at data and so on about how it's all working together and how we can improve our use of the environment to better protect it. So that is part of the audit, and it is done independently. Now governments actually try to respond to the recommendations of the audit, and I think they actually put it right in the audit report. So that process is still evolving, and it is improving over time. At the end of the day, it's still up to politicians to follow the recommendations and make sure that they get implemented, but it is an independent process. Thanks.
Okay, thank you.
Well, basically, that's it. Like I said, I was going to make it short, but those are my main concerns, because like I said, it does involve the future of the generations right now, and what's going to be happening down south is going to affect a great deal what's going to be happening up north in the future, especially if that pipeline goes through. And that's my concern.
All right. Thank you again, Mr. Como. We appreciate your submission. We have that on the record. Is there anybody else from the public that would like to speak to Bill 38, Protected Areas Act? In fact, Bill 39 is Environmental Rights Act, or Bill 44, the Forest Act. Does anyone from the public care to speak to Bill 38, 39, or 44 any further this evening? Also, it's always becoming of members to recognize their colleagues, both current and former members. So I'd like to take this opportunity to recognize longtime Hay River MLA Jane Gronewagen. Thank you and welcome, and thank you for being here. Without further ado, if there are no more comments or presentations from the public, do members agree that this agenda item is concluded? Agreed. All right. Thank you. I will do that. Yes, I've been reminded to remind you that if anybody does have, any member of the public has written submissions that they care to provide us, we would welcome those, and we would ask that you contact Michael Ball here at the end of the table, our committee clerk, or you're certainly welcome to go to the Legislative Assembly's website, and all the contact information for our committee is there. So we want to thank you all once again. It's been a great honor and pleasure to come here to the town of Hay River and be able to listen to hear what you have had to say tonight. And while there was only a couple presenters, the amount of information was very robust and extensive, and we're grateful and appreciative of that. So without further ado, we can be adjourned. Thank you.